Hey everybody, I'm Max Pines. I'm a lawyer, Max Pines Law. I do criminal cases and civil rights in Albuquerque, New Mexico and all over New Mexico. And I wanted to talk to you guys about preliminary hearings and grand juries. So many of my clients, when they have a new felony case, when a family member or a loved one or a friend has a potential felony case that's going forward in court, they want to know, how is this case going to proceed? How does it get to trial? And the answer to this is a little complicated, so it's worth going over. In New Mexico, we all have the right to force the government to make a formal finding of probable cause of any felony charge before it gets to the district court. So if they can't show that probable cause for the felony, it doesn't go to the district court. It can't go to trial. It's something that the government has to do. It's a hurdle they have to pass before a case becomes official. And it's an important protection that we have. But it also makes the process a little more complicated. Making that formal finding of probable cause, there's two ways that they can do it. They can have a preliminary hearing, they could have a grand jury. And they're very different types of processes. Either way, they could end up with that formal finding of probable cause that'll take it to the district court, that'll take it to the process of discovery, that'll take it to that process of a jury trial. Preliminary hearing is essentially a mini trial. I call it a mini trial because it's conducted in a way that you might have a trial in. You have a judge, you have a prosecutor, you have a defense attorney, and importantly, you have witnesses. To make a showing of probable cause at a preliminary hearing, the district attorney has to bring in those witnesses, and those witnesses have to testify. They have to testify and meet the elements of that alleged felony, and that testimony has to make it to probable cause. It's a low standard of proof, so it's not beyond a reasonable doubt, but it is a standard that they have to meet, and they have to meet it with those witnesses. Preliminary hearing is, without a doubt, the more favorable for the defendant. And it's more favorable because this is a public hearing. You get a chance to cross-examine the witness. You're going to get discovery, so you're going to get some information about the case beforehand. You're going to have a chance to have your attorney negotiate with the prosecutor. And sometimes there's a deal or a favorable plea to be made. And this negotiation, it can be very favorable, and it can get you important information. And if you have that preliminary hearing, you're going to get evidence, and it's going to be on the record, and it's going to be a huge guide to letting you know what this case is all about and how it's going to proceed. That contrasts with the grand jury. So grand jury is very different. Grand jury is a secret hearing. There's just the jurors, the grand jurors, and the district attorney and the witness. And it's closed, it's in secret. And you and your lawyer, we can't go to it. We don't get to hear that testimony. And we don't get to force them to follow the rules of evidence. We don't get to cross-examine the witness. We can't even go. And the only way we can go is if you, the defendant, testify. And that's something I, as a criminal defense attorney, very seldom want my clients to do because there's no discovery. We don't know what this case is about. All we know is that there's a charge and it's serious enough to make that prosecutor want to bring it in front of a grand jury. Grand jury is going to be more likely with the more serious types of charges, more complicated charges that the prosecutor doesn't think that they can effectively prosecute with the preliminary hearing because they don't want to bring all those witnesses. They don't want to expose them to our cross-examination. When you get a target letter telling you have a grand jury hearing, you know you have a very serious situation and you need to contact a lawyer as soon as possible. Either way, the prosecution can get that showing of probable cause, and once they do that, then it goes to the district court, and we begin that whole process that we typically and traditionally conceive of as a jury trial. So we get ready, and it becomes a big process. But this first part is an important and crucial way that it gets to that process. And it's important. It's important to engage an attorney early, because an attorney that knows what they're doing, knows how to get the information, and knows how to fight when we have the opportunity. You can take advantage of that opportunity, and your resolution is going to be ultimately a lot better the sooner you engage in this process, the sooner you engage a competent, rational, reliable, effective, aggressive attorney to get in on the case. So that's why it's important for you all to know about this. Preliminary hearing and grand jury, getting that finding of probable cause to get it to the district court to bring it to trial. I hope this has been helpful. I hope it allays some stress, because it's stressful to have this alleged felony case and not knowing how it's going to proceed. You can learn a lot more if you go to my website, maxpineslaw.com. I have a lot of blogs on this topic and a bunch of other topics closely related to this. So I appreciate your time, and I hope you have a great day. Thank you.